Is that a new lady giving you any trouble?
No.
She seems like a pretty reasonable human being. And optimistic.
That's good.
No, now look at the mess here. Judge Tannenbaum, this is Chris Porzan. Are you able to hear us right now? Oh, there you are.
Yeah,
The First District Court of Appeal is now in session. All who have business before this court draw near. Give attention and you shall be heard. God save these United States, the great state of Florida, and this honorable court.
Good afternoon. Before us on the docket today is one case, Allstate Fire and Casualty Insurance Company versus Zachary John Petros. It's consolidated case numbers 21327 and 23068. If counsel for the appellant is ready to proceed, you may begin.
Kansas Gooden for the appellant Allstate. I'd like to reserve 4 minutes of time for rebuttal.
So noted.
May it please the court. Courts have limited the common law confession of judgment doctrine in the insurance context. It is not absolute. An insurance company does not automatically owe fees every time payment is made. Instead, the Florida Supreme Court created this legal fiction in Waller to overcome the express wording of section 627428. And courts have only applied this doctrine to 3 statutes. 1, the 627428, 6269373, which is an identical statute which only applies to surplus lines, and the PIP statute, which expressly incorporates 627428. And even there, it's limited to situations where an insurer unreasonably withholds payment and forces the insured to file suit. And the courts examined whether the lawsuit is the necessary catalyst to obtain those benefits. And here, Petros is seeking to expand this common law doctrine to other statutory schemes. No appellate court has ever applied the confession of judgment under these circumstances. In fact, the statute specifically states that 627428 does not apply unless the insurance company denies the claim, which Allstate did not do here.
counsel, is that what Allstate argued in the trial court as to why the trial court had no authority to enter the $25,000 judgment against Allstate?
They argued that it is not a confession of judgment and that it was a cure under the bad faith statute.
Right, but did Allstate argue that the court didn't have authority to enter the $25,000 judgment because there was no confession of judgment doctrine to apply?
Not specifically. It was more along the lines of that the case should be dismissed as moot because it does not apply as a matter of law. But I think that's part and parcel because when you get down to the confession of judgment doctrine and whether it applies or not, it is a common law doctrine and it doesn't apply as a matter of law here. Again, is it even a common law doctrine, or is it just a matter of statutory interpretation with respect to particular provision? I think it's a common law doctrine because if you read the cases leading up to Woolard and then Woolard, it specifically says, we think that this would be basically absurd and would penalize the insured for not having this in that context, the 627428. And so that's the context of which it has applied in the past. And it's never been applied in the scheme like this, especially where a carrier has cured in CRN in the bad faith context.
Counsel, let me ask you a question. Perhaps you've answered it in part already. Assume we don't have the CRN cure in the background. And what we have is the only facts are that Allstate tendered the full policy limits as a settlement for the claim. Would that amount to a confession of judgment under the common law?
I don't think so. And I think, again, if you go back to the Woolard case and all of the cases applying that doctrine in the insurance context, it only applies to those 3 statutes. And those 3 statutes do not apply here. And so I don't think even with just a tender, I don't think it necessarily would have been a confession of judgment.
What I don't understand, though, Ms. Gooden, it is a common law doctrine, and you just confirmed it is. In response to Judge Tannenbaum's question, why wouldn't it apply beyond those 3 statutes? It would be potentially applicable to any statute that didn't say it was not applicable, would it not?
I know, because the common law, the way it is carved out, the Florida Supreme Court has been very clear. Well, let me back up a second. I think for this court to affirm the trial court's judgment, it has to expand this common law doctrine to the other statutory situations. And the Florida Supreme Court has been very clear that expanding the common law should be a rarity. And in order to do it and alter that common law, it has to be demanded by public necessity or where required to vindicate fundamental rights. And this is absolutely missing in this situation.
Well, let me just go back to something Judge Tannenbaum asked. And as I read Woolard, it does seem more like a statutory interpretation case. And in fact, the dissent respectfully disagrees because it reads the plain language of the statute differently. So if it's merely a statutory interpretation analysis and not a common law, how does that change your argument, if at all?
I mean, if it's still a statutory interpretation, they were only interpreting 627-428, which again does not apply here in this situation. And so again, I think it would still be into that statute and how it applies. And if you think about that statute and the entire purpose of it, it's about leveling the playing field for a plaintiff, basically to have fees at the end of the day in order to get an attorney. It's an access to access to justice consideration, which you don't have in the UM context. A lawsuit, it's a tort suit. Attorneys work on a contingency fee. And so that's why the same considerations are not here in the UM context. And so I think because it's been applied in that 627-428 context, kind of putting it in, essentially putting, a square into a round hole, it just doesn't fit. And it just, again, there's no, basically leveling of the playing field required.
Counsel, what would typically, so let's take the CRN out of it and let's look at a more typical Woolard kind of case where the insurance company pays on the policy after a suit's been filed. How would that proceeding look? Would it be that the court would enter a judgment against the insurance company for the amount that the insurance company paid and then you deal with fees, or would it be a dismissal like Allstate sought with a reservation to deal with fees notwithstanding the dismissal?
Well, I think it depends on the type of case. If it is a case specifically where 627-428 applies, I think in that situation, it would fall in that confession of judgment arena. A judgment would be issued and then fees would be dealt with. However, where that statute does not apply, I think the situation becomes moot. There is no relief that a trial court can grant at that point, and then the case should be dismissed.
What's the basis for that conclusion that there would be a judgment entered against the insurance company that's already paid? Because Woolard says that the payment would be the functional equivalent or would operate in effect as if it were a confession of judgment. So Woolard does not say that it's actually a confession of judgment. It operates the same as if it had been. So, and that would be for purposes of the application of 627-428. I'm having a hard time understanding how the payment by an insurance company could ever be the basis for a judgment against that insurance company for the same amount that it just paid.
I agree with you, Your Honor. I don't think that a payment that the carrier just made should be a judgment against it. And that's why I think it should be either dismissed if there are no fees on the table, or if it's a 627-428 situation, that's when the Woolard case comes into play and the confession of judgment doctrine to apply those fees.
So then why didn't Allstate argue that as a basis for avoiding the $25,000 judgment entered against it? It spent a lot of time, if not exclusively, spent its time talking about, well, it was really a settlement on the CRN. It had nothing to do with the claim that was cited in the cover letter with the check. Why didn't Allstate raise that more specifically, or did it? And is it preserved as an issue?
I think it is preserved because if you look at the totality of that hearing, that was a very lengthy hearing, and there was a lot of focus on the cure and why that payment was made. And it was specifically done to cure that CRN under the bad faith statute. And so, again, if you look back at the overall argument that was made, that confession of judgment does not apply as a matter of law and that it cannot be liable for fees, I think that encompasses all of that and everything is actually preserved.
Counsel, if your position is correct and this should have been dismissed below, would Allstate have an argument that it is in fact entitled to fees under 768.79 by virtue of its proposal?
No, I don't think it should or could, because in that situation, I think it would be unfair. Again, because this is I would almost put that in that, was it Central versus Shaw case where, let me see if I can find the facts of it. But it was talking about how, somebody accepted a proposal for settlement rejected a proposal for settlement, then settled the case and then came back to get fees. The third DCA set forth that is a very unfair situation. And I think if Allstate came back and tried to get fees and costs against Mr. Petrus, I think that would be definitely unfair.
Counsel, could you give a more textual based response to Judge Ray's question? Like based on 768.79 as opposed to fairness? As in the alternative, not to undermine your fairness argument, but it would also be helpful to hear a textual argument.
Well, it wouldn't be a technical judgment for no liability. It would just be a dismissal. And I believe there is case law, and I don't believe the briefing went into this about dismissals and how PFSs operate in that context. But I think that would be the major difference between a dismissal versus a judgment.
Is it Allstate's position then that the $25,000 judgment, that the trial court didn't have the authority to enter that judgment against Allstate?
Yes, I don't think it did. And again, it goes back to the confession of judgment shouldn't have been entered. It's inappropriate as a matter of law. And so therefore, the case should have been dismissed.
Talking about the common law, this common law concept of confession and judgment, let's put it in the context of like Carroll v. Gore, for instance, or even if you go back, Blackstone talks about confessions of judgment, and it's typically in a contract or in a promissory note debtor creditor situation. Is it your position that confession of judgment as a concept, common law, whatever, historically, is limited to contractual relationships where confession of judgment is provided as provision, like in Carroll v. Gore and other historical situations like that?
I think so. And the thing about those two cases, the legislature enacted 5505 afterwards, and it voided that statute. Basically says that confession of judgments through a power of attorney are null and void. And so it seems to even make those cases overruled. And so to me, that's the legislature stepping in to overrule and kind of overcome that common law doctrine.
Just so I understand, claims are contractual claims, correct?
They are sort of. They're kind of a hybrid because you are suing for benefits, so they would fall under the 5-year statutory statute of limitations. However, they're treated as tort suits because the carrier steps into the shoes of the tortfeasor, and so you essentially have a negligence case.
But without a contract, there's no case. There has to be an insurance contract.
It is true. But again, and I think the claims are unique in the fact that it ultimately you're trying a tort case. And so I think that is what distinguishes it from a basic contract case because these damages are unliquidated. They're not liquidated.
And along those lines, counsel, is there anything in this particular policy that that mentions confessions of judgment or offers a confession of judgment as an available remedy if there's a breach in some way?
No, sir, there is not. In fact, the policy does contain language that says that each party would pay their own fees and costs. However, we can see that was not asserted below. And I see I have 26 seconds, so I'm going to reserve that for rebuttal.
Thank you, Ms. Gooden. Madam Clerk, if you would please extend appellate counsel's time by 4 minutes. We'll keep it even and easy for you, and we will, of course, extend Mr. Howard's time the same amount. Mr. Howard, you may begin when you're ready.
Thank you, Your Honor. May it please the court, my name is Bailey Howard, and I represent the appellee in these proceedings, Mr. Zachary John Petrus. Your Honors, the logical place to begin seems to be with the end of the second brief that Mr. Petrus filed in this case, responding to a concern that Judge Tannenbaum raised concerning whether the court had the power to enter a judgment in this case. And first, that's not an argument that Allstate fully preserved below, but even if this court does conclude that Allstate preserved that argument and that they could argue that the trial court did not have the authority to enter a judgment, despite the fact that it lacks executory language, meaning Mr. Petrus can't collect on it, then this court should nonetheless affirm the fact that Allstate confessed judgment because under Woolard and under Ivy and other cases that Mr. Petrus cited in his brief and that this court has referred to today, the payment of the disputed claim, once litigation began, but before a final judgment was entered, functions as, and here the courts differ whether it is the equivalent of a judgment or the equivalent of a verdict or the equivalent of a confession of judgment, on all of those claims. Or on that claim particularly. And
Mr. Howard, though, I think Ms. Gooden pointed out correctly so that the Woolard case and its progeny were dealing with a different statute. They were dealing with, as you know, 627.428, and we don't have that applicable here. So whether it's a case of statutory interpretation or common law, how does that argument apply in this case?
It applies this way, Your Honor. Woolard and the other cases that Ms. Gooden was referring to are cases that deal with entitlement to attorney's fees under section 627.428. But in those cases, the courts make clear that it's conducting two distinct analyses. The first analysis is how you become a prevailing party. And that's the common law doctrine of confession of judgment. It does not apply only in insurance cases or only in 627.428 cases. Judge Tannenbaum alluded to Carroll versus Gore, which is a case involving a promissory note. Liberty Transportation LLC versus Banyan Air Services, a fourth DCA case from 2009 involved judgment liens. St. Regis Paper Company versus Watson, a Supreme Court of Florida case in 1983, it applied it to compensatory damages for fraud. And there was even Lieber versus Lieber, a 1949 Supreme Court of Florida case with a special master's fee in a divorce case. And the common thing that links all those cases is that a party paid a disputed claim in the midst of litigation over that payment, but before a final judgment was entered on it and on who owed it. And that operated as a confession of judgment as to that claim. The analysis of whether you're entitled to attorney's fees under section 627.428, a statute that the parties here agree does not apply and that the law, and I hesitate to use this word in an oral argument, but that the law is clear that it doesn't apply here. That's a separate analysis. And Woolard and Johnson versus Omega Insurance Company, a 2016 case from the Supreme Court of Florida, and every case that the parties refer to in their briefs that discusses this doctrine in that context makes clear that it distinguishes between how you prevail on the merits, which is a necessary criterion to obtain fees for an insured under section 627.428, and the entitlement to attorney's fees under 627.428. And note 2 in Woolard makes clear in very stark terms that the reasonableness of proceeding with the litigation and so forth are preconditions to entitlement to attorney's fees under 627.428. The only case that doesn't do it.
I'll leave. I'm sorry, counsel. Go ahead, and I'll ask at the end.
I'm sorry, Your Honor. I was just going to say the only case that doesn't do a great job of distinguishing is the fourth DCA's decision, Bryant versus Giovera, but it still makes the distinction.
Counsel, so I mean, taking you back to Waller, though, Waller does not talk about prevailing party. What it talks about is what is the meaning of judgment as used in 627-428. Do you disagree that Waller is a straight interpretation case dealing with 627-428 and that particular word or combined words?
No, Your Honor, I don't disagree with that at all. Wallard was the issue that was presented in Wallard was discussing whether a settlement was sufficient to qualify as a judgment under 627.428. However,
Waller deals with whether it operated as the functional equivalent of a judgment, not whether it was a judgment or could be a judgment.
Yes, Your Honor, it's the functional equivalent of a confession of judgment or verdict in favor of the insured.
Right. And so are there any cases that support the idea beyond Waller or after Waller that supports the idea that confession of judgment has somehow morphed into something more than it historically had been to allow for an entry of judgment against an insurance company for the exact amount of money that it had already paid to what affect them becomes the judgment creditor?
Yes, Your Honor, there are, and I'll answer that with an asterisk that I'll return to in just a moment. There is, in fact, Johnson versus Omega Insurance Company, which is from 2016. That was decided after Wallard, where the Supreme Court of Florida said it is well settled that the payment of a previously denied claim following initiation of an action for recovery, but prior to the issuance of a final judgment, constitutes the equivalent of a confession of judgment. And then Mady versus Daimler Chrysler, which was a 2011 decision of the Supreme Court of Florida, which dealt with entitlement under a federal statute. Section 627.428 was nowhere in sight. And the asterisk that I mentioned earlier, and to which I would now like to return if it please the court, is that Your Honor said that this was expanding the common law beyond what it historically had been. And that's not an accurate reflection of what Florida law was. Florida law has as a common law principle of how you deal with it when a party just pays a claim during the middle of litigation and says, you know what, we're wrong, and we do owe you this money. That's what the confession of judgment doctrine is. And it exists in the background under Florida law, except to the extent it's circumscribed by statute or the decision of a court of last resort. And so it's not compressed by any statute that either Mr. Petrus or Allstate were able to find into just the insurance context. It exists in other contexts as well and continues to in a vital way to this day. So section 627.428 is one arena where it seems to come up frequently, but that's not the only place that it arises, certainly.
Well, so Waller's dealing with this statute, 627.428, which presumably is a remedial type statute. Presumably that would be interpreted in favor of the insured or construed a little bit more broadly. I'm assuming you acknowledge that 768.79 is a punitive statute and is to be construed narrowly. Are we on the same page on that first?
Not exactly, Your Honor. They should both be construed narrowly because they're both in derogation of the common law. And I can't bring it to mind at this moment, but there is, in fact, it may have been either Woolard or Johnson where the Supreme Court said 627.428 should also be construed narrowly because it's in derogation of common law.
All right, well, let's just focus on 768.79, and that at a minimum is to be construed narrowly. I'm having a hard time then figuring out what the argument is as to how the use of the doctrine, so to speak, in the context of one statute could be applied to interpret or to construe the meaning of judgment in 768.79. So when it's to be strictly construed. So could you address that?
Yes, Your Honor, certainly. The most straightforward way to address that probably is to note that when the legislature uses the same words in two different statutes, it usually intends those words to mean the same thing. Another way to put it is that it is a common law doctrine that is not related necessarily to the issue of attorney's fees unless there's a statute entitling you to attorney's fees. So the fact that you're a prevailing party in Florida does nothing for you unless you have some statute entitling you to attorney's fees, because under the American rule, each party bears its own fees. And that's what applies if there's no statutory or contractual means to recover fees. So the confession of judgment rule, it doesn't really link to a particular statute. It's just about, did you recover judgment? Did you prevail and did you obtain judgment? And it's
yeah, but to the extent that we're talking about Wallard, it is tied to a statute. It's tied to a very specific statute in a very specific context, and so, and the purpose behind 768-79 differs from the from the purpose of the fee provision that was a subject in Wallard.
I'm not sure it does differ in such a material way, Your Honor, because under section 768.79, of course, the purpose is to encourage settlements by, on the one hand, providing an award of attorney's fees if you don't settle when it's reasonable to do so, but also requiring that the offers be within be reasonable offers and based on a reasonable assessment of the damages and liability. And section 627.428 is a statute that provides an insured can recover attorney's fees from their insurer if they prevail in litigation. And courts have added the gloss, which is not found in the text of the statute, admittedly, but courts have added the gloss that the insurer must have forced the insured to continue with the litigation past the point at which it was reasonable to do so, which in practical terms is just what 768.79 does. It creates efficient economic incentives to settle at an efficient time and punishes a party for the failure to use the information at their disposal efficiently and effectively.
Is there a single case, though, that characterizes 627.428 as a punitive measure or as a penalty for not settling?
Not that I'm aware of, Your Honor, no.
But there are several cases that characterize 768.79 as a penalty, right?
Yes, Your Honor. Its mechanism has been much more fully explored, perhaps because it's more complex than the mechanism of section 627.428, excuse me. Section 768.79 and the exact meaning of its provisions and the significance of its provisions have received significantly more attention from the courts. But if you look at the language of the two statutes and what they do, what we can intuit at least about their purpose and what we know about their function from reading their text lines them up pretty closely. They're just two different situations, and one of them requires that the one of them in the different situation being 768.79 requires that a party take some affirmative action first, that is to say, serving a proposal for settlement to establish entitlement under it. Whereas section 627.428, all you have to do is win, so to speak. But
speaking of different situations, I want to go back to the two cases you've cited in support of your argument, Johnson and Mady. In Mady, my recollection is that involved basically a consent judgment that was entered after a proposal for settlement was offered and accepted. And so here we don't have that. We don't have an accepted proposal for settlement. So how is that case analogous, or how does that case support your argument here?
That case goes to support one of the concerns that Judge Tannenbaum raised about what does judgment mean and what is sufficient to count as a judgment. The basis for attorney's fees in Mady was not the proposal for settlement. It was a federal statute regarding warranties that the lawsuit was brought under. And that was a straightforward prevailing party statute. And when you're the party who has prevailed is what the court was considering there. And this supports Mr. Petrus's argument here, because the issue is, what does it mean under the common law in Florida when a party pays a disputed claim in mid-litigation, but before the judgment has been entered? And despite the various labels courts have applied to it at various points, the function of that act remains the same under the common law. And the entitlement to attorney's fees and the mechanisms of entitlement to attorney's fees may differ depending on which statute the attorney's fees are sought under. But
how is that just help me understand, how is that a common law doctrine as opposed to just a plain application of the text of 768.79 that says once you have a proposal for settlement that's been accepted, it becomes enforceable by the court? That was the basis of the consent decree, correct?
Yes, Your Honor, it was. And if I'm understanding Your Honor's question correctly, then the way that it becomes a common law doctrine rather than just an interpretation of section 768.79 is that the court was looking in Mady to see whether the judicial imprimatur of approving the settlement was sufficient. And the issue there was that the party had paid a disputed claim in mid-litigation. And if there hadn't been the federal warranty statute that the case was brought under, then the payment of the proposal for settlement would have ended the case. And there would have been no subsequent question of attorney's fees. But because this federal statute was out there providing a separate means to recover for attorney's fees beyond section 768.79, the court had to interpret based on the basis for which the parties were seeking attorney's fees, whether it was sufficient to trigger entitlement under that statute, meaning is this a person a prevailing party when there is a settlement in that case? And the facts of this case.
Well, when there is, just to be clear, when there is a settlement under 768.79, which is not what we have here.
Yes, Your Honor. We have here something even stronger than that, where there was no settlement. This was a check that was tendered without any conditions and self-evidently without any conditions, but then without any discussion or settlement negotiations between the parties of any kind. And so if a settlement is good enough, then surely a unilateral, voluntary, and unconditional payment is also going to be enough. And Your Honors, there are two additional matters I want to touch on in the brief time that remains to me.
I'm sorry, counsel, but I want to touch, there's something that's still bothering me, I'm trying to understand, and that has to do with what is a judgment, which I don't think you were contending that there isn't a judgment for the plaintiff and against the defendant in this case for $25,000. The effect of a judgment is to change the legal relationship between two parties. It rendered, in a money judgment, it turns the plaintiff into a judgment creditor and the defendant into a judgment debtor. How could it be that the trial court could enter a judgment against Allstate and in favor of your client in the amount of $25,000, essentially saying that Allstate owes your client $25,000 based solely on the fact that Allstate had already paid your client $25,000?
Your Honor, because in this case, the fact that Allstate had already paid was reflected in the judgment. The judgment says, Allstate, you owed Mr. Petrus $25,000. You acknowledged that fact, you have paid it, and now this matter is done. But as I mentioned at the beginning of my argument, Your Honor, the necessity of entering a judgment may be a formality here that isn't necessary under the Supreme Court's case law, saying that the payment, the confession of judgment, is the functional equivalent that is sufficient in the case. And the trial court would probably have to close its file somehow just as an administrative necessity. But it may be that the confession of judgment alone is sufficient to act as a judgment, because unlike the traditional confession of judgment cases that involve debts, we don't have to worry about attachment, perfection, or priority here. There's not going to be execution. There's no out-of-state collections action. And so
counsel, you think that we could make that assertion without having to construe 768.79 like the Supreme Court construed the 627 statute in Woolard?
I think this court could do it without construing section 768.79, or perhaps only lightly construing it to say that the functional equivalent of a judgment is under section 768.79, a judgment obtained, and that it would be good enough under those circumstances based on the Supreme Court's case law. And Your Honors, one thing that I should mention in this brief time that remains to us is that Allstate repeatedly in its briefs asserts that Mr. Petrus frustrated it from obtaining a compulsory medical examination, and I'll use the shorthand CME. And there's no direct evidence in the record to say that Mr. Petrus left the scheduled CME only after it was automatically canceled pursuant to the court's order. But there is some circumstantial evidence, and that's in Allstate's motion to compel a rescheduled CME, because the trial court scheduled that CME with the condition that if the exam was not taking place within 30 minutes of the scheduled start time, it was automatically canceled and Mr. Petrus could leave. And then in its motion to compel, the trial court also imposed one further condition, which was that if the exam was automatically canceled in that way, Allstate would pay Mr. Petrus's costs and fees for the rescheduled exam. And its motion to compel at page 236 of the case 3068 record, Allstate says it's ready and willing to pay those fees and costs, which makes no sense if it was Mr. Petrus's fault that the exam failed. If there are no further questions, we would ask that this court affirm. Thank you, Your Honors.
Thank you, Mr. Howard. Ms. Gooden, you may proceed.
Yes. I have kind of 4 short points to hit. Mr. Howard argued preservation at the very beginning of his argument. That is something he did not argue in his briefs and brought up today for the first time. Number 2, I want to touch on the comment about this being a voluntary payment. It was not. And what is painfully missing from the trial court's order and from Mr. Howard's argument is that this payment was specifically under the bad faith statute to cure the CRN. And if you can just look at the response to the CRN, that specifically states that to cure the CRN, the allegations. And so, you know, Mr. Howard and the trial court kind of blatantly ignored that.
Well,
What
but
do you do with the check and the cover letter? I mean, the check couldn't be any clearer: in payment for underinsured motorist, Florida, date of loss. Isn't it the trial court's obligation to evaluate what's in front of the trial court, including this check and the cover letter?
But I think you can't evaluate that without looking at the actual CRN response, which said we will tender the limits to cure the CRN, and then that payment was made within 60 days. And Florida law is very clear that if you tender the limit within 60 days, that is a cure. Talent, Gallant, there's a ton of cases that specifically touch on that.
counsel, why can't it be both? I mean, I don't understand why Allstate is fighting so hard the idea that whatever reason that it paid $25,000 or tentative policy limits, it could have been for the CRN, it could have been for this case, it could have been for both. Why does it matter whether it was for one or the other? The fact remains that Allstate paid its limits and it claimed that the matter was moot. Why the focus on the CRN versus what Judge Jay just asked you about?
Well, I think it's because the assertion of the plaintiff's attorney below, immediately moving to confess judgment against Allstate. Because if you look at the emergency motion of Allstate to dismiss the case, it was very apparent that the plaintiff attorney refused to dismiss it. And so therefore it was moving because trial was coming up. And that it needed the matter to be taken off the docket and to be dismissed because the plaintiff attorney wouldn't do it himself. So that's why the focus was on the bad faith cure.
Right, but the fact remains, I mean, what Allstate asserted in its motion is that it's moot because it paid everything that it's obligated to pay under the policy.
Correct.
And by the way, that was the complaint. The complaint was seeking recovery under the policy.
Correct.
So Allstate argued mootness. And Judge Day is asking you, Judge Day asked you a question, and the response goes back to the CRN thing as opposed to why isn't it just moot? Because there's nothing left to pay. Allstate can't be a judgment debtor at this point, and there's no basis to enter a judgment against Allstate. Why do you need the CRN argument?
It probably isn't necessary kind of under that because it is moot. And as I mentioned earlier, the confession of judgment doctrine had never been applied in this context before. So they probably could have just relied on moot. But I think it was just the allegations of the plaintiff's attorney that kind of forced Allstate to really put forth that the evidence of the CRN response. And I do think the CRN response goes to the overall picture of what was going on. I mean, the trial court penalized and sanctioned Allstate for fulfilling its duty under 624155. And I think that is a problem. It is holding Allstate liable for fees for doing what is required to do under the law. And there are some serious due process issues with that. And, State Farm versus Lorenzo, the 50 CA kind of talks about that. You can't hold a carrier liable for fees for doing what it already is doing under the law. And so for these reasons, we ask this court to reverse and remand for dismissal of this case. And again, we think that I am out of time, so thank you.
Thank you. Thank you to both counsel for your excellent advocacy today. The court stands adjourned.
Thank you.
Yeah.
Thank you.
Good
Thank
seeing
you, Your Honor.
everybody.